Let's now discuss the International Court of Justice ruling today and the possible impact on the ongoing Israel-Gaza conflict. I have Charles Adeogun Phillips. He's a former United Nations genocide and war crimes prosecutor and international lawyer. Good to see you, Charles, and thanks for your time as always. Now, let's start with how all this started. How was South Africa in the first place able to bring this case against Israel, since it is not directly affected by what is going on in the Gaza Strip?
Good evening, Sly. South Africa sought to base the court's jurisdiction on Article 36 of the Statute of the ICJ and also on Article 9 of the Genocide Convention, to which both South Africa and Israel are state parties. They're contracting parties to that convention. Now, this case raises important issues concerning the Genocide Convention itself. The provisions in the Genocide Convention impose a fundamental obligation on contracting states to the convention, in that all state parties to the convention have an interest of their own in the proper interpretation, application, and fulfillment of those obligations. And this is so regardless of whether or not they are directly affected by the alleged violations. In addition, the prohibition against such an egregious conduct, such as genocide, is a pre-entry norm in international law. And what does that mean? Well, what it means is that South Africa was capable of bringing a case before the court on behalf of the international community as a whole. That is what we refer to in international law as common interest rights and duties, which are enshrined in various conventions, international conventions, and in this case, the Genocide Convention. So the prohibition contained in the Genocide Convention is often referred to as an absolute one. It's not an obligation, it's an absolute prohibition. Therefore, it is not enough for Israel to argue that it has acted in self-defense or in response to some form of provocation by Hamas. Israel's response must therefore be conducted within the ambit of international law, as you've rightly pointed out, and genocide cannot be justified. There are absolutely no exceptions. And this is basically what gave rise to the proceedings that you were discussing.
Okay, so is this crime of genocide different from any other international crime? And if so, how is it different?
The crime of genocide is different from other international crimes. The first point to be made is that genocide in itself is the crime of crimes. There is no graver crime known to mankind than a genocide. And what sets genocide apart from other international crimes is that it's the only crime where the perpetrator must be shown to have committed the alleged acts with the requisite specific intent to destroy in whole or in part members of a national, racial, or ethnic group. So the killing of one person may amount to a genocide, provided that the prosecutors can demonstrate that that killing was done with the requisite specific intent, which we call in law the dolus specialis, to destroy in whole or part members of that national or ethnic group. It's also a crime that is codified under international law, the Genocide Convention. So to that end, the prohibition contained in the Genocide Convention is an absolute one, like I've just pointed out. It's not an obligation, it's an absolute right. It's an absolute prohibition.
So what are the enumerated or prohibited acts under Article 2 of the Genocide Convention?
There are 4 of them. Very quickly. These include killings of members of a group, causing serious bodily or mental harm to members of a group, the deliberate infliction on members of a group of conditions that are calculated to bring about its physical destruction, either in whole or in part, and finally, imposing measures intended to prevent births within that group. So, for example, if you target babies in a maternity ward, for example, that is seen as an act to stop the reproduction of certain members of this group. So those 4 prohibited acts may constitute the crime of genocide, provided that they are perpetrated with that specific requisite intent to destroy members of a group in whole or in part. That's what makes it a genocide, and that's what sets it apart from any other international crime.
Well, Charles, we understand there are provisional measures under Article 41, if you will. Let's talk about these provisional measures obtained today. We understand that the court has yet to hear the main case. So why are these provisional measures needed?
Provisional measures are sought to protect what we often refer to as core rights under the convention. They're not a request for a determination on the merits of the case brought before the court. They're just being requested by the applicant, in this case South Africa, where the applicant believes that there is a risk of irreparable harm or prejudice, and that if the court does not impose these provisional measures, it will suffer irreparable harm or prejudice. And that is why parties would seek provisional measures. As you rightly pointed out, the case on the merits will not be heard for another 2 or 3 years.
So were there any surprises in connection with today's ruling? I'm looking at it, 15 in favor and 2 against. Israel and Uganda issued dissenting judgments.
Yes, that was very, very surprising for international law practitioners like myself. As you rightly pointed out, there were 17 judges on the panel. 15 judges ruled in favor and 2 judges wrote dissenting opinions. Judge Aaron Barak of the State of Israel dissented, which was understandable. But surprisingly, Judge Julia Sebutunde of the Republic of Uganda issued an 11-page dissenting judgment. Now, Judge Sebutunde, I have read her dissenting opinion, and Judge Sebutunde seemed to argue that the dispute between South Africa and Israel is essentially a historical and political one between Israel and the Palestinians, rather than a legal matter for the court. She also found that the provocative statements alleged to have been made by senior Israeli officials, as alleged by South Africa, as being evidence of genocidal intent on the part of Israel, were taken completely out of context. She felt that those comments rather referred to Hamas as opposed to Palestinian people. And finally, Judge Sebutunde argued that in the order to Israel to do everything possible to prevent genocide merely restates existing duties of Israel under international law and are therefore redundant. So 3 major points of dissent, which we found quite astonishing, actually.
So what in your view is the significance of today's ruling for South Africa?
Well, the ruling is very significant in my view, in that it's indicative of the fact that the court accepts that there is an urgent, real, and imminent risk that irreparable justice may be caused to the rights that are enshrined in the Genocide Convention between now and when the case on the merits is decided. In essence, the ICJ has determined that Israel's action against the Palestinians in Gaza are plausibly, on the face of it, genocidal in nature. And to that end, it's ordered these provisional measures. From where I'm standing, that in and of itself requires some measure of finding, at least on the face of it, that Israel has committed one or more of those genocidal acts that I just referred to in Article 2 of the Genocide Convention.
And just before you go, perhaps let's talk about the impact of today's ruling. What would it have on Israel and perhaps South Africa? Is the ruling binding?
Well, the ruling is binding. There is enough jurisprudence in the court from 2001 in the Legrand brothers judgment that this is the basic function of the court is the settlement of disputes, international disputes judicially, and every order made by the court is binding. So I expect that Israel will take steps to prevent the commission of further acts by its military and report back to the court. Because one of the major features of this judgment is that Israel is required to report back to the court within 1 month. I also expect that South Africa will, and other contracting states to the Genocide Convention, would in turn continue to monitor Israel's actions in Gaza and would report back to the court if there are any violations of those measures. But most importantly, this ruling is particularly important as it binds all contracting parties to the Genocide Convention to ensure they have a duty to ensure that the state of Israel abides with the court's ruling. So those are the three significant things that I expect will emanate from a ruling like this.
And if we can do this in 30 seconds, something personal here, because you led a high-profile genocide trial back then in 2006 and 2007. What does such a ruling evoke in you as an international lawyer?
All sorts of sentiments. It takes me back to almost 2 decades ago when I did this work at the Rwanda Tribunal. Genocide, like I said, is the crime of crimes. There is no excuse, and impunity in the world cannot be tolerated under any excuse. And I'm very pleased and happy about today's outcome.
Well, Charles Adeogun Phillips, many thanks for speaking with us here on Arise Newsnight.